Question 1. What factors determine the suitability of an applicant for a pistol or revolver permit in Rhode Island, and how should an issuing authority ethically and legally navigate potential ambiguities in an applicant's stated purpose for seeking the permit? Option A. A comprehensive review of the applicant's submitted documentation, a direct interview to clarify their stated purpose and assess their demeanor, and an objective evaluation against Rhode Island's statutory disqualifying factors. Option B. Denying the permit based on a general feeling of unease about the applicant's character, even in the absence of specific disqualifying information. Option C. Solely relying on the applicant's written statement of purpose for the permit, assuming their stated reason is sufficient without further inquiry. Option D. Making assumptions about the applicant's potential misuse of the firearm based on their occupation or personal background, without concrete evidence. The correct answer is A. A comprehensive review of the applicant's submitted documentation, a direct interview to clarify their stated purpose and assess their demeanor, and an objective evaluation against Rhode Island's statutory disqualifying factors. Explanation. This scenario presents a professional challenge because it requires balancing the applicant's stated intent with the objective assessment of their suitability to carry a firearm, as mandated by Rhode Island law. The licensing authority has a dual responsibility: to uphold public safety by ensuring only qualified individuals are licensed, and to process applications fairly and without undue prejudice. Careful judgment is required to avoid both arbitrary denial and the issuance of a permit to someone who may pose a risk. The best professional approach involves a thorough, objective review of all submitted documentation and a direct, non-confrontational interview to clarify any ambiguities or concerns. This approach aligns with Rhode Island General Laws Section 11-47-11, which outlines the criteria for issuing a pistol or revolver permit, emphasizing the applicant's suitability and the absence of disqualifying factors. The interview allows for direct assessment of the applicant's demeanor, understanding of firearm safety, and the legitimacy of their stated reasons for seeking a permit, all while respecting their rights. This method ensures a comprehensive evaluation based on established legal standards and ethical considerations of due diligence. An approach that focuses solely on the applicant's stated reason for wanting a permit, without further investigation into their background or demeanor, is professionally unacceptable. This fails to meet the legal requirement to assess suitability and could overlook potential risks, thereby compromising public safety. It also neglects the ethical obligation to conduct a thorough review. Another professionally unacceptable approach is to deny the permit based on a subjective feeling or a vague concern about the applicant's character without concrete evidence or specific legal grounds for disqualification. This can lead to arbitrary decisions, potentially violating the applicant's rights and failing to adhere to the specific disqualifying factors enumerated in Rhode Island law. Finally, an approach that involves making assumptions about the applicant's intentions or potential misuse of the firearm based on stereotypes or limited information is ethically and legally flawed. This demonstrates bias and a failure to conduct an objective assessment, which is a cornerstone of responsible licensing procedures. Professionals in this role should employ a decision-making framework that prioritizes objective evidence, adherence to statutory requirements, and a commitment to fairness. This involves systematically gathering all relevant information, conducting interviews to clarify facts and assess demeanor, and making decisions based on established legal criteria rather than personal biases or assumptions. The process should be transparent and well documented. Question 2. The evaluation methodology shows an applicant for a Rhode Island license or permit to carry a pistol or revolver has submitted an application detailing a recent series of perceived threats and expressing significant fear for their personal safety. During a subsequent interview, the applicant becomes visibly distressed and reiterates their urgent need for a permit. What is the most professionally sound and legally compliant approach for the licensing authority to take in Rhode Island? Option A. Issue the permit immediately based on the applicant's expressed fear and distress, as this demonstrates a clear and present danger justifying immediate self-defense. Option B. Share the applicant's personal details and the nature of their perceived threats with local community watch groups to gather informal opinions on the applicant's suitability. Option C. Deny the permit solely because the applicant displayed emotional distress during the interview, as this may indicate an inability to handle a firearm responsibly. Option D. Conduct a thorough review of the applicant's submitted documentation, verify the legitimacy of their stated need against Rhode Island's legal requirements for a proper and legitimate need, and conduct a professional interview to clarify details and assess overall suitability, ensuring all decisions are based on statutory criteria. The correct answer is D. Conduct a thorough review of the applicant's submitted documentation, verify the legitimacy of their stated need against Rhode Island's legal requirements for a proper and legitimate need, and conduct a professional interview to clarify details and assess overall suitability, ensuring all decisions are based on statutory criteria. Explanation: this scenario presents a professional challenge because it requires balancing the applicant's perceived need for self-defense with the strict legal requirements for obtaining a permit to carry a pistol or revolver in Rhode Island. The licensing authority has a duty to uphold public safety by ensuring that only qualified individuals are granted such permits, while also respecting the rights of law-abiding citizens. The applicant's emotional state and personal history, while relevant to their perceived need, must be evaluated against objective criteria established by Rhode Island law. The best professional approach involves a thorough and objective review of the applicant's submitted documentation and a direct, professional interview. This approach prioritizes adherence to Rhode Island general laws, specifically those pertaining to the issuance of pistol permits, e.g., Regal Section 11-47-11, and related statutes. The licensing authority must verify that the applicant meets all statutory requirements, including demonstrating a proper and legitimate need for carrying a pistol or revolver, and that they are not disqualified by any criminal history or other legal prohibitions. The interview allows for clarification of any ambiguities in the application and an assessment of the applicant's demeanor and understanding of safe firearm handling and legal responsibilities. This method ensures that the decision is based on established legal standards and a comprehensive understanding of the applicant's qualifications, thereby upholding both public safety and due process. An approach that relies solely on the applicant's subjective claims of fear without independent verification or objective assessment of their stated need is professionally unacceptable. This fails to meet the legal standard of demonstrating a proper and legitimate need, as required by Rhode Island law, potentially leading to the issuance of a permit to someone who does not meet the statutory criteria. Such a decision would undermine public safety and disregard the legislative intent behind the permit process. Another professionally unacceptable approach is to deny the permit based solely on the applicant's emotional distress during the interview, without a thorough review of their application and supporting documentation against the legal requirements. While emotional distress might be a factor in assessing an applicant's suitability, cannot be the sole basis for denial if all other legal criteria are met. This approach risks an arbitrary and capricious decision, failing to provide a legally defensible reason for denial and potentially violating the applicant's rights. Finally, an approach that involves sharing the applicant's personal information or the details of their application with individuals not authorized by law to receive such information is a serious ethical and regulatory violation. This breaches confidentiality and could have severe consequences for the applicant, while also exposing the licensing authority to legal repercussions. All interactions and decisions must be conducted with strict adherence to privacy laws and the established procedures for handling sensitive personal information. Professionals in this role should employ a decision-making framework that begins with a comprehensive understanding of the relevant Rhode Island statutes and regulations governing pistol permits. This framework should include a systematic review of all submitted documentation, a structured interview process designed to elicit necessary information and assess the applicant's suitability, and a clear, documented rationale for any decision made, ensuring it is grounded in legal requirements and ethical considerations. Question 3. The evaluation methodology shows that a Rhode Island resident, whom you have known personally for many years and consider a close friend, has applied for a license or permit to carry a pistol or revolver. You are the licensing officer responsible for reviewing such applications. What is the most ethically sound and professionally responsible course of action to take in this situation? Option A. Deny the application outright due to the personal relationship, believing it is the safest way to avoid any appearance of impropriety, even if the applicant meets all legal requirements. Option B. Immediately recuse yourself from reviewing the application and inform your supervisor of the conflict of interest, ensuring the application is handled by another qualified officer. Option C. Discuss the applicant's personal life and shared memories with them during the review process to build rapport, while still conducting a standard review of their qualifications. Option D. Proceed with reviewing the application, assuring yourself that your personal friendship will not influence your objective assessment of the applicant's qualifications and adherence to Rhode Island law. The correct answer is B. Immediately recuse yourself from reviewing the application and inform your supervisor of the conflict of interest, ensuring the application is handled by another qualified officer. Explanation: the evaluation methodology shows a scenario that is professionally challenging due to the inherent conflict between personal relationships and the impartial application of licensing laws. The applicant's long-standing friendship with the licensing officer creates a significant ethical dilemma, as it could be perceived as influencing the decision-making process, even if no actual undue influence is exerted. This situation requires careful judgment to uphold the integrity of the licensing process and public trust in law enforcement. The best professional approach involves recusing oneself from the application process due to the perceived or actual conflict of interest. This approach is correct because it adheres to fundamental ethical principles of impartiality and avoiding even the appearance of impropriety. Rhode Island General Laws Title 11, Chapter 11-47, concerning firearms, implicitly requires that licensing decisions be made based solely on the applicant's qualifications and adherence to legal requirements, free from personal bias or favoritism. By recusing, the officer ensures that the application is reviewed by an unbiased party, thereby safeguarding the integrity of the licensing system and preventing any potential challenges to the legitimacy of the permit issuance. This action demonstrates a commitment to professional ethics and the rule of law. An incorrect approach would be to proceed with the review and approval of the application, rationalizing that the friendship will not influence the decision. This is professionally unacceptable because it disregards the appearance of impropriety, which can be as damaging as actual misconduct. It violates the ethical obligation to maintain public trust and could lead to accusations of favoritism, undermining the fairness of the licensing process. Another incorrect approach would be to deny the application solely because of the friendship, without a legitimate legal basis. This is professionally unacceptable as it constitutes an arbitrary and capricious decision, failing to uphold the legal standards for permit issuance. The denial must be based on disqualifying factors outlined in Rhode Island law, not on a personal relationship. Finally, an incorrect approach would be to discuss the applicant's personal life or unrelated matters during the application review, attempting to create a sense of camaraderie to ease the process. This is professionally unacceptable as it deviates from the objective assessment required by law and introduces an element of personal interaction that is inappropriate for a licensing decision, potentially blurring the lines between professional duty and personal acquaintance. Professionals should employ a decision-making framework that prioritizes ethical conduct and adherence to legal mandates. When faced with a potential conflict of interest, the first step is to recognize the situation and its implications. The next step is to consult relevant departmental policies and state laws regarding conflicts of interest and recusal. If a conflict is identified, the professional should immediately notify their supervisor and formally recuse themselves from any involvement in the matter, ensuring that the process is handled by an impartial party. This systematic approach protects both the individual officer's integrity and the public's confidence in the institution. Question 4. The evaluation methodology shows that an applicant for a Rhode Island license or permit to carry a pistol or revolver has presented a compelling narrative of personal fear and anxiety due to recent, but uncorroborated, neighborhood incidents. The applicant states they feel unsafe in their home and community and believes carrying a firearm is the only way to protect themselves. What is the most appropriate course of action for the licensing authority in Rhode Island? Option A. Deny the permit based on a personal assessment that the applicant appears overly anxious and may not be a responsible firearm owner, without specific evidence of disqualification. Option B. Conduct a thorough review of the applicant's background, verify residency, and objectively assess the stated need for self-defense against the specific legal requirements, and establish precedents for proper showing of need under Rhode Island General Laws, Chapter 11-47, seeking further documentation or clarification if necessary. Option C. Issue the permit immediately based on the applicant's expressed fear and the subjective feeling of unsafety, as the primary purpose of the permit is personal protection. Option D. Postpone the decision indefinitely, citing the need for further review without providing the applicant with a timeline or specific reasons for the delay. The correct answer is B. Conduct a thorough review of the applicant's background, verify residency, and objectively assess the stated need for self-defense against the specific legal requirements and establish precedents for proper showing of need under Rhode Island General Laws, Chapter 11-47, seeking further documentation or clarification if necessary. Explanation. This scenario presents a professional challenge because it requires balancing the applicant's stated need for self-defense with the legal requirements for obtaining a permit to carry a pistol or revolver in Rhode Island. The licensing authority has a duty to ensure that permits are issued only to individuals who meet the statutory criteria, which includes demonstrating a proper showing of need and being of good character. The applicant's personal circumstances, while potentially distressing, must be evaluated against the objective standards set forth in Rhode Island law. The best approach involves a thorough and objective assessment of the applicant's stated need for self-defense, strictly adhering to the criteria outlined in Rhode Island General Laws, Chapter 11-47, specifically concerning the issuance of pistol permits. This includes verifying the applicant's residency, ensuring they are not disqualified by any criminal history or other statutory prohibitions, and critically evaluating the proper showing of need, as interpreted by Rhode Island courts and the Rhode Island State Police, who are responsible for issuing these permits. This approach prioritizes legal compliance and public safety by ensuring that only qualified individuals receive permits, based on established legal standards rather than solely on subjective emotional appeals. An approach that relies solely on the applicant's emotional distress and fear, without a rigorous evaluation of the specific, articulable threats or circumstances that constitute a proper showing of need under Rhode Island law, is procedurally flawed. This could lead to the issuance of a permit to someone who does not meet the legal threshold, potentially compromising public safety. Another incorrect approach would be to deny the permit based on a personal judgment about the applicant's character or perceived trustworthiness, without any factual basis or legal justification. Such a denial would be arbitrary and capricious, violating due process and potentially exposing the licensing authority to legal challenge. The decision must be grounded in the applicant's eligibility under the law, not on the personal biases of the licensing official. Furthermore, an approach that involves delaying the decision indefinitely without a clear reason or communication with the applicant fails to uphold the principles of administrative fairness and efficiency. Applicants have a right to a timely decision on their permit application, and any delays must be justified by the need for further investigation or clarification, conducted in good faith. Professionals should employ a decision-making process that begins with a clear understanding of the relevant statutes and regulations governing pistol permits in Rhode Island. This involves gathering all necessary documentation from the applicant, conducting thorough background checks, and objectively assessing the applicant's stated need against the legal definition of proper showing of need. If further information or clarification is required, the applicant should be informed and given an opportunity to provide it. The final decision must be based on a comprehensive review of all facts and a strict application of the law, with clear documentation of the reasoning. Question 5. The evaluation methodology shows that an applicant for a Rhode Island pistol or revolver permit has a history of documented domestic disturbances, though no criminal charges were ever filed or convictions obtained in relation to these incidents. The applicant states they are seeking the permit for personal protection. What is the most responsible and legally compliant course of action for the licensing authority? Option A. Issue the permit without further investigation, as the absence of criminal convictions means the applicant legally qualifies. Option B. Focus the decision-making process on the applicant's stated need for personal protection and their perceived emotional stability during the application process, rather than the past incidents. Option C. Conduct a thorough review of all submitted documentation, including the nature and frequency of the domestic disturbances, and assess whether this history, in conjunction with other factors, demonstrates the applicant is a suitable person to possess a firearm under Rhode Island general laws, potentially requiring further investigation or an interview. Option D. Immediately deny the permit application based on the documented history of domestic disturbances, as this indicates a potential risk to public safety. The correct answer is C. Conduct a thorough review of all submitted documentation, including the nature and frequency of the domestic disturbances, and assess whether this history, in conjunction with other factors, demonstrates the applicant is a suitable person to possess a firearm under Rhode Island general laws, potentially requiring further investigation or an interview. Explanation. This scenario presents a professional challenge because it requires balancing a citizen's right to self-defense with the responsibility to ensure firearms are not possessed by individuals who pose a risk to themselves or others, all within the specific legal framework of Rhode Island. The applicant's past behavior, even if not resulting in a criminal conviction, raises concerns about their judgment and temperament, which are critical factors in determining suitability for firearm possession. Careful judgment is required to avoid both infringing on lawful rights and compromising public safety. The best approach involves a thorough and objective review of all available information, prioritizing the safety and welfare of the public and the applicant, and adhering strictly to Rhode Island general laws governing pistol permits. This means carefully considering the documented instances of domestic disturbance, even without a conviction, as they may indicate a pattern of behavior that could compromise responsible firearm ownership. The licensing authority must weigh this information against the applicant's stated reasons for seeking a permit and any other relevant background checks. The ultimate decision must be grounded in a good faith assessment of whether the applicant meets the statutory requirements for a permit, which implicitly includes demonstrating a capacity for responsible and safe firearm handling and possession, free from behaviors that suggest a propensity for violence or recklessness. This approach upholds the principle of responsible gun ownership while respecting due process, an approach that dismisses the documented domestic disturbances solely because no criminal charges were filed is professionally unacceptable. While a lack of conviction is a factor, it does not negate the potential risk indicated by the documented incidents. Rhode Island law requires licensing authorities to consider all relevant information when determining suitability, and ignoring documented behavioral issues, even without a conviction, could lead to a permit being issued to an individual who may not be a responsible gun owner, thereby failing in the duty to protect public safety. Another professionally unacceptable approach is to deny the permit solely based on the documented domestic disturbances without a comprehensive review of all factors. While safety is paramount, individuals are entitled to due process. A denial must be based on a reasoned assessment of how these past incidents, in conjunction with other information, demonstrate that the applicant is not a suitable person to possess a firearm under Rhode Island law. A blanket denial without such a nuanced evaluation could be arbitrary and legally challengeable. Furthermore, an approach that focuses primarily on the applicant's perceived emotional state or personal beliefs, rather than objective behavioral indicators and statutory requirements, is also flawed. While an applicant's demeanor might be observed during an interview, the decision to grant or deny a permit must be based on established legal criteria and documented facts, not subjective interpretations of personality. The professional decision-making process for similar situations should involve a systematic evaluation of all submitted documentation, including the application, references, and any background checks. It requires a thorough understanding of Rhode Island general laws pertaining to firearms and permits. When concerning information arises, such as documented domestic disturbances, the licensing authority must conduct further inquiry, which may include interviewing the applicant or relevant parties, to gather a complete picture. The decision must then be made based on a holistic assessment of whether the applicant meets all legal qualifications and poses no undue risk to themselves or the public, with a clear, documented rationale for the decision. Question 6. The evaluation methodology shows that an applicant for a Rhode Island pistol permit has expressed significant fear for their personal safety due to recent increases in crime in their immediate neighborhood and a specific, though uncorroborated, incident of being followed home. The applicant states they need the permit to feel safe walking to and from their place of employment. Which of the following approaches best reflects the proper procedure for evaluating this application under Rhode Island law? Option A. Issue the permit immediately due to the applicant's expressed fear and the general increase in neighborhood crime, as this demonstrates a clear need for self-protection. Option B. Thoroughly review the applicant's stated reasons and any supporting documentation to determine if they meet the legal standard of proper and justifiable need, as defined by Rhode Island General Laws, Chapter 11-47, which requires more than a generalized fear of crime. Option C. Deny the permit application without further investigation, as generalized fears about neighborhood crime do not constitute a sufficient legal basis for carrying a concealed weapon. Option D. Advise the applicant to seek a permit for sport shooting purposes, as their stated need for personal safety is unlikely to be met by a concealed carry permit. The correct answer is B. Thoroughly review the applicant's stated reasons and any supporting documentation to determine if they meet the legal standard of proper and justifiable need, as defined by Rhode Island General Laws, Chapter 11-47, which requires more than a generalized fear of crime. Explanation: this scenario presents a professional challenge because it requires balancing the applicant's perceived need for self-defense with the strict legal requirements for obtaining a Rhode Island pistol permit. The applicant's personal circumstances, while emotionally compelling, do not automatically override the established legal criteria and the responsibility of the licensing authority to ensure public safety. Careful judgment is required to avoid both undue leniency and unwarranted denial. The best professional approach involves a thorough review of the applicant's stated reasons against the specific criteria outlined in Rhode Island General Laws, Chapter 11-47, particularly concerning the demonstration of a proper and justifiable need for carrying a pistol or revolver. This approach requires the licensing authority to objectively assess whether the applicant's concerns, such as potential threats or documented instances of harassment, rise to the level of a demonstrable and immediate danger that cannot be mitigated through other means. The law requires more than a generalized fear. It necessitates a concrete justification that aligns with the statutory definition of proper and justifiable need. This ensures that permits are issued only to individuals who meet the legal standard, thereby upholding public safety and the integrity of the permitting process. An incorrect approach would be to grant the permit based solely on the applicant's emotional distress and generalized fear of crime in their neighborhood. This fails to meet the legal threshold of proper and justifiable need, as defined by Rhode Island law. The law requires a specific, demonstrable threat, not merely a subjective feeling of insecurity. Another incorrect approach would be to dismiss the application outright without a comprehensive review of the applicant's stated reasons and any supporting documentation. While the applicant must meet the legal standard, a complete and fair evaluation of their submission is a fundamental aspect of due process and professional conduct. Ignoring the applicant's concerns without proper consideration would be a failure to adhere to the procedural requirements of the application process. A further incorrect approach would be to suggest that the applicant obtain a permit for reasons unrelated to self-defense, such as for sport shooting or collection, if their stated purpose is clearly for personal protection. The proper and justifiable need must be directly related to the intended use of carrying a concealed weapon for self-defense, as per the intent of the law. The professional decision-making process for similar situations should involve a systematic evaluation of all submitted information against the relevant statutory requirements. This includes understanding the specific legal definitions and criteria e.g., proper and justifiable need in Rhode Island, objectively assessing the evidence presented by the applicant, considering any corroborating information, and making a determination based strictly on the law and established policy, while maintaining fairness and due process for the applicant. Question 7. The evaluation methodology shows that an individual approaches a Rhode Island pistol permit licensing official, stating they are the sibling of a current permit holder and urgently need to know if their sibling's permit is still valid because they are concerned about the sibling's recent erratic behavior. What is the most appropriate and legally compliant course of action for the licensing official to take in Rhode Island? Option A. Attempt to informally verify the individual's identity and their relationship to the permit holder through a quick phone call to a mutual acquaintance before deciding whether to disclose the information. Option B. Inform the individual that due to privacy regulations under Rhode Island law, the status of another person's pistol permit cannot be disclosed without proper legal authorization or a formal, legally permissible request process, and then guide them on any applicable procedures for such requests, Option C. Immediately disclose the permit status to the individual, explaining that their concern for their sibling justifies an exception to the usual privacy rules. Option D. Advise the individual to contact their sibling directly to inquire about the permit status, without offering any further information or guidance on official procedures. The correct answer is B. Inform the individual that due to privacy regulations under Rhode Island law, the status of another person's pistol permit cannot be disclosed without proper legal authorization or a formal, legally permissible request process, and then guide them on any applicable procedures for such requests. Explanation: the evaluation methodology shows that ethical considerations are paramount when handling sensitive information related to firearm permits in Rhode Island. This scenario is professionally challenging because it involves a direct request for information that, if disclosed improperly, could have severe legal and safety ramifications. The applicant's perceived urgency and personal connection create a pressure to act quickly, but adherence to established procedures and privacy laws is non-negotiable. Careful judgment is required to balance the applicant's request with the legal obligations of the permit-issuing authority. The best professional approach involves strictly adhering to Rhode Island general laws, specifically those pertaining to the confidentiality of firearm permit applications and the procedures for accessing such records. This means informing the applicant that their request cannot be fulfilled directly due to privacy regulations, and guiding them through the legally prescribed process for obtaining information, which typically involves a formal request and a demonstration of legitimate need, if applicable under Rhode Island law. This approach upholds the integrity of the permitting process, protects the privacy of all applicants, and ensures compliance with state statutes designed to prevent misuse of sensitive data. Disclosing the status of another individual's permit application, even to someone claiming a familial relationship, is a regulatory and ethical failure. Rhode Island law places strict limits on who can access such information and under what circumstances. Violating these confidentiality provisions can lead to disciplinary action, fines, and erosion of public trust. Another incorrect approach is to dismiss the request outright without explaining the proper procedure. While it avoids improper disclosure, it fails to educate the applicant on the legal framework and may lead to frustration or further attempts to circumvent the process. A professional response should always include guidance on the correct path forward. Finally, attempting to verify the relationship through informal means or making an exception based on the applicant's perceived sincerity is also a failure. Such actions bypass the established legal safeguards and create a precedent for inconsistent and potentially discriminatory application of the law. Professionals in this role should employ a decision-making framework that prioritizes legal compliance, ethical conduct, and procedural fairness. This involves 1. Identifying the core issue, a request for confidential information. 2. Recalling relevant Rhode Island statutes and departmental policies regarding record access and privacy. 3. Evaluating the request against these legal and policy frameworks. 4. Communicating the legal limitations clearly and respectfully to the requester. 5. Providing clear instructions on the authorized procedures for obtaining information, if any exist. 6. Documenting the interaction and the decision made. Question 8. The evaluation methodology shows that an applicant for a Rhode Island pistol or revolver permit has submitted an application detailing a generalized fear of crime in their neighborhood and a desire for personal protection. The applicant expresses significant anxiety, but has not provided specific documentation of threats or a history of being targeted. Considering the Rhode Island general laws governing the issuance of pistol permits, which of the following represents the most appropriate professional response? Option A. Deny the application immediately due to the applicant's emotional state, as individuals experiencing significant anxiety may not be suitable for firearm ownership. Option B. Conduct a thorough review of the applicant's submission to determine if the stated fear and desire for protection meet the legal standard for a proper and justifiable reason, as defined by Rhode Island law, requesting further specific evidence if necessary. Option C. Issue the permit based on the applicant's expressed anxiety and fear, as personal safety is a paramount concern for all citizens. Option D. Advise the applicant on how to strengthen their application by emphasizing their fear and suggesting they seek out situations that could be perceived as threatening to justify their need. The correct answer is B. Conduct a thorough review of the applicant's submission to determine if the stated fear and desire for protection meet the legal standard for a proper and justifiable reason, as defined by Rhode Island law, requesting further specific evidence if necessary. Explanation. This scenario presents a professional challenge because it requires balancing the applicant's perceived need for self-defense with the strict legal requirements for obtaining a Rhode Island pistol permit. The applicant's personal circumstances, while emotionally compelling, do not automatically override the statutory criteria established by Rhode Island law for the issuance of such permits. The core of the challenge lies in adhering to the legal framework while acknowledging the applicant's stated concerns. The best approach involves a thorough and objective review of the applicant's submission against the specific criteria outlined in Rhode Island General Laws, Chapter 11-47, particularly concerning the demonstration of a proper and justifiable reason for carrying a pistol. This means meticulously examining the evidence provided to ascertain if it meets the legal standard for proper and justifiable need, which typically requires more than a generalized fear of crime. The applicant must demonstrate a specific threat or a demonstrable risk that goes beyond what an average citizen might experience. This approach is correct because it directly aligns with the statutory mandate for the licensing authority to assess applications based on established legal criteria, ensuring public safety and responsible firearm ownership. It upholds the principle that permits are granted based on legal qualifications, not solely on subjective feelings or generalized anxieties. An incorrect approach would be to grant the permit based solely on the applicant's emotional appeal and stated fear of crime, without independently verifying if these fears meet the legal threshold for a proper and justifiable reason. This fails to uphold the law, as it bypasses the required evidentiary standard, and could lead to the issuance of permits to individuals who do not meet the legal qualifications, potentially compromising public safety. Another incorrect approach would be to dismiss the application outright due to the applicant's perceived emotional state, without a comprehensive review of the provided documentation against the legal requirements. Emotional distress is not a legal justification. The applicant's concerns must still be evaluated within the framework of the law. A blanket denial based on the applicant's demeanor, rather than the substance of their application, is procedurally flawed. Finally, an incorrect approach would be to advise the applicant on how to fabricate or exaggerate their circumstances to meet the proper and justifiable reason standard. This is not only unethical but also illegal, as it involves misrepresentation and subverts the integrity of the permitting process. The professional decision-making process for similar situations should involve a systematic review of all submitted documentation. This includes identifying the specific legal requirements for the permit, objectively assessing the evidence presented by the applicant against those requirements, and making a determination based solely on the legal merits of the application. If the applicant's submission is insufficient, the applicant should be clearly informed of the deficiencies and the legal basis for the denial, with an opportunity to provide further evidence if applicable and legally permissible. Question 9. The evaluation methodology shows that a Rhode Island police chief, who is responsible for reviewing and approving applications for a license or permit to carry a pistol or revolver, discovers that the applicant is their sibling. What is the most ethically sound and legally compliant course of action for the police chief to take in Rhode Island? Option A. Deny the application solely because of the familial relationship, without a full review of the applicant's qualifications. Option B. Proceed with the review and approval of the application, believing that the applicant is a responsible individual and the relationship will not influence their judgment. Option C. Immediately inform their supervisor of the familial relationship and formally recuse themselves from any involvement in the review, processing, or decision-making regarding the application. Option D. Approve the application, but make a note in the file disclosing the familial relationship to the applicant. The correct answer is C. Immediately inform their supervisor of the familial relationship and formally recuse themselves from any involvement in the review, processing, or decision-making regarding the application. Explanation. The evaluation methodology shows that this scenario is professionally challenging because it requires an applicant to balance personal relationships with the strict requirements of Rhode Island law regarding firearm permits. The core of the challenge lies in the potential for bias or undue influence when a close personal connection exists between the applicant and the issuing authority. Rhode Island General Laws, Chapter 11-47, specifically addresses the licensing and regulation of firearms, emphasizing the need for responsible ownership and the prevention of firearms falling into the wrong hands. Law places a significant burden on licensing authorities to ensure that applicants meet all statutory requirements, including demonstrating good character and a proper purpose for carrying a pistol or revolver. The best professional approach involves adhering strictly to the established legal procedures and recusing oneself from any part of the decision-making process where a conflict of interest, or even the appearance of one, exists. This means that the licensing official, upon recognizing the familial relationship with the applicant, must immediately inform their supervisor and formally recuse themselves from reviewing, approving, or denying the application. This action upholds the integrity of the licensing process, prevents any perception of favoritism, and ensures that the application is evaluated objectively by an impartial party, in accordance with Rhode Island's commitment to fair and unbiased law enforcement. An incorrect approach would be to proceed with the review and approval of the application, rationalizing that the applicant is a responsible individual and the relationship is not a factor. This fails to acknowledge the appearance of impropriety and violates the ethical obligation to maintain public trust in the licensing system. Such an action could be seen as a breach of duty and potentially a violation of Rhode Island general laws, which implicitly require impartiality in administrative decisions. Another incorrect approach would be to approve the application but disclose the relationship to the applicant, believing this transparency is sufficient. While disclosure is a step, it does not resolve the fundamental conflict of interest. The decision-making authority still rests with someone who has a personal stake, however acknowledged, in the outcome. This approach still leaves the process vulnerable to accusations of favoritism and undermines the objective assessment mandated by law. A further incorrect approach would be to deny the application solely based on the familial relationship, without a thorough review of the applicant's qualifications and adherence to all other statutory requirements. This is discriminatory and fails to uphold the principle that permits should be granted or denied based on objective criteria outlined in Rhode Island law, not on personal connections alone. The professional reasoning process in such situations should involve a clear understanding of the relevant statutes and ethical guidelines. When a potential conflict of interest arises, the professional must first identify it. Then, they should consult internal policies and procedures regarding conflicts of interest and recusal. The next step is to take decisive action to remove themselves from the situation, typically through formal recusal and notification of a supervisor. This ensures that the process remains fair, transparent, and legally compliant, safeguarding both the integrity of the system and public confidence. Question 10. Operational review demonstrates that a Rhode Island resident is applying for a pistol or revolver permit. The base application fee is $40. The mandatory background check fee is $15. And a state-mandated processing fee is $5. What is the correct total fee to be collected from the applicant? Option A, $60. Option B, $40. Option C, $50. Option D, $55. The correct answer is A, $60. Explanation. Scenario analysis. This scenario presents a professional challenge involving the accurate calculation of fees for a pistol permit application in Rhode Island. Miscalculating these fees can lead to either undercharging, which results in a financial loss for the state and potential noncompliance with fee statutes, or overcharging, which can be perceived as unfair to the applicant and may deter legitimate applications. Adherence to the specific fee structure outlined in Rhode Island law is paramount for maintaining the integrity of the licensing process and ensuring equitable treatment of all applicants. Correct approach analysis. The best professional practice involves meticulously calculating the total fee by summing the base application fee, the required background check fee, and any applicable processing or administrative fees as stipulated by Rhode Island general laws. This approach ensures full compliance with the statutory fee requirements, prevents financial discrepancies, and upholds the principle of fairness to the applicant. Specifically, Rhode Island General Laws Section 11-47-11 outlines the fees associated with pistol permits, and any amendments or administrative rules promulgated by the Rhode Island Attorney General's office must be consulted for the most current figures. Accurate calculation demonstrates diligence and respect for the legal framework governing firearm permits. Incorrect approach is analysis. An approach that calculates the fee based solely on the base application fee without accounting for the mandatory background check fee is incorrect because it fails to adhere to the comprehensive fee structure mandated by Rhode Island law. This omission leads to an undercollection of required funds, violating the specific provisions of Section 11-47-11. An approach that adds a flat percentage for administrative costs without a specific statutory basis or regulatory authorization is also incorrect. While administrative costs are a reality, they must be accounted for through legally defined fees. Introducing an arbitrary percentage deviates from the established fee schedule and could be challenged as an unauthorized charge. An approach that rounds the total calculated fee down to the nearest whole dollar without justification is incorrect. Fee collection must be precise as per statutory requirements. Rounding down results in undercollection, similar to omitting specific fees, and is not supported by any provision in Rhode Island's pistol permit regulations. Professional reasoning. Professionals tasked with processing pistol permit applications in Rhode Island should employ a systematic decision-making framework. This involves 1. Identifying all applicable statutory and regulatory provisions related to permit fees, e.g., Rhode Island General Laws Section 11-47-11 and any relevant administrative rules. 2. Obtaining the most current fee amounts from official sources. 3. Performing a precise calculation by summing all mandated components. 4. Verifying the calculation against the statutory requirements. 5. Documenting the calculation process for transparency and auditability. This methodical approach ensures accuracy, compliance, and ethical conduct. Question 11. Operational review demonstrates that an applicant for a Rhode Island pistol or revolver license has been arrested in the past for a misdemeanor offense, but the charges were subsequently dismissed by the court. The applicant is unsure whether this arrest must be disclosed on the license application. Which of the following actions represents the most responsible and legally compliant approach for the applicant? Option A. Omit the arrest from the application, believing that a dismissed charge is not significant enough to report. Option B. Assume that since the record may have been sealed or expunged, disclosure is not required. Option C. Only disclose arrests that resulted in a conviction, as the charges were dismissed in this instance. Option D. Fully disclose the arrest and its dismissal on the application, providing any requested supporting documentation. The correct answer is D. Fully disclose the arrest and its dismissal on the application, providing any requested supporting documentation. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the nuances of Rhode Island's firearm licensing process, specifically concerning the disclosure of past legal encounters. The challenge lies in accurately interpreting the scope of what must be disclosed and understanding the potential consequences of incomplete or misleading information, which can directly impact the licensing decision and future firearm ownership rights. Careful judgment is required to ensure full compliance with Rhode Island general laws. Correct approach analysis. The best professional practice involves a thorough and honest disclosure of all relevant information as required by Rhode Island general laws, specifically focusing on any arrests, regardless of whether charges were ultimately dismissed or records were sealed. This approach is correct because Rhode Island law mandates disclosure of arrests for certain offenses, even if no conviction resulted. The application for a pistol or revolver license requires truthful and complete answers to all questions. Failing to disclose an arrest, even one that did not lead to a conviction, can be considered a false statement on the application, which is grounds for denial or revocation of a license under Rhode Island law. This upholds the integrity of the licensing process and ensures public safety by providing licensing authorities with a complete picture of an applicant's history. Incorrect approach is analysis. One incorrect approach is to only disclose arrests that resulted in a conviction. This is a regulatory failure because Rhode Island law often requires disclosure of arrests for specific offenses, irrespective of the final disposition. Omitting arrests that were dismissed or resulted in a nolle prosequi can be interpreted as providing incomplete or misleading information on the application, violating the requirement for truthful and complete answers. Another incorrect approach is to assume that because an arrest record was sealed or expunged, it does not need to be disclosed. This is an ethical and regulatory failure. While sealing or expungement may limit public access to records, the licensing application process may still require disclosure of the underlying event, especially if the law specifically asks about arrests or encounters with law enforcement. The intent of the law is to allow licensing authorities to assess an applicant's suitability, and withholding information about a past arrest, even if sealed, can undermine this objective. A further incorrect approach is to only disclose arrests that the applicant believes are serious enough to warrant disclosure. This is a subjective and dangerous interpretation of the law. The application questions are designed to be comprehensive, and the applicant's personal judgment about the severity of an arrest is not a substitute for adhering to the explicit requirements of the Rhode Island general laws regarding disclosure. This approach risks omitting crucial information that licensing authorities are legally entitled to review. Professional reasoning. Professionals facing similar situations should adopt a framework of when in doubt, disclose. This means carefully reading every question on the application, and if there is any ambiguity about whether an event needs to be disclosed, erring on the side of providing the information. It is advisable to consult the specific Rhode Island general laws pertaining to firearm permits, and if necessary, seek legal counsel to understand the precise disclosure requirements. The overarching principle is to be completely truthful and transparent with the licensing authority, as the integrity of the process and public safety depend on it. Question 12. Process analysis reveals that an applicant for a Rhode Island pistol or revolver permit has consumed a moderate amount of alcohol at a social gathering and is considering carrying their legally owned handgun home. The applicant believes they are still in control and can handle the firearm safely. Which of the following represents the most appropriate understanding of Rhode Island law regarding this situation? Option A. The prohibition on carrying a pistol or revolver while under the influence of intoxicating liquor only applies to carrying in public places, not in one's own vehicle or private property. Option B. Carrying a pistol or revolver while under the influence of intoxicating liquor is strictly prohibited by Rhode Island law, regardless of the applicant's subjective assessment of their ability to handle the firearm. Option C. The law primarily focuses on enforcement if an actual incident occurs, meaning carrying a pistol or revolver after consuming a moderate amount of alcohol is acceptable as long as no disturbance is caused. Option D. Carrying a pistol or revolver is permissible as long as the individual does not appear visibly intoxicated and believes they can still handle the firearm safely. The correct answer is B. Carrying a pistol or revolver while under the influence of intoxicating liquor is strictly prohibited by Rhode Island law, regardless of the applicant's subjective assessment of their ability to handle the firearm. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant for a Rhode Island pistol/revolver permit to accurately recall and apply specific legal requirements concerning firearm possession while under the influence of alcohol. Misinterpreting or misapplying these laws can lead to serious legal consequences, including denial of the permit, criminal charges, and a permanent record that could affect future rights. The applicant must demonstrate a clear understanding of Rhode Island's stance on carrying firearms while intoxicated, which is a critical safety and legal consideration. Correct approach analysis. The best approach involves the applicant demonstrating a thorough understanding that Rhode Island General Laws Section 11-47-52 explicitly prohibits carrying a pistol or revolver while under the influence of intoxicating liquor or a controlled substance. This understanding is crucial for responsible firearm ownership and is a fundamental requirement for obtaining a permit. The applicant must recognize that any level of impairment from alcohol while carrying a firearm is a violation of Rhode Island law, regardless of whether they believe they can still handle the weapon safely. This approach directly addresses the legal prohibition and prioritizes public safety and adherence to the law. Incorrect approaches analysis. One incorrect approach is to believe that as long as the applicant feels capable of handling the firearm safely and does not appear visibly intoxicated, it is permissible to carry a pistol or revolver after consuming a small amount of alcohol. This fails to recognize that Rhode Island law establishes a strict prohibition based on the presence of alcohol, not on a subjective assessment of impairment. Law does not provide a threshold for safe intoxication. Another incorrect approach is to assume that the prohibition only applies to carrying a firearm in public places and not in one's own home or private property. Rhode Island General Laws Section 11-47-52 applies to carrying a pistol or revolver, and the statute does not carve out exceptions for private property when the individual is under the influence. A further incorrect approach is to think that the prohibition is only enforced if an incident occurs. This is a dangerous assumption that disregards the proactive nature of law enforcement and the legal requirement to refrain from carrying while impaired, irrespective of whether a specific event triggers an investigation. The law is a preventative measure. Professional reasoning. Professionals seeking a Rhode Island pistol/revolver permit must adopt a decision-making framework that prioritizes strict adherence to all applicable Rhode Island general laws. This involves proactively researching and understanding the specific prohibitions and requirements outlined in the relevant statutes, such as those pertaining to carrying firearms while under the influence. When faced with situations involving potential impairment, the professional decision-making process should involve a clear no-carry rule if any alcohol has been consumed, to ensure full compliance with the law, and to uphold the highest standards of public safety and responsible firearm handling. Question 13. The performance metrics show a concerning trend in applications for a Rhode Island license to carry a pistol or revolver where applicants attempt to satisfy the firearm safety training requirement through means not explicitly recognized by state law. Considering the strict adherence required by Rhode Island General Laws Title 11, Chapter 47, which of the following actions by an applicant would be the most appropriate and legally compliant method to demonstrate the required firearm safety training? Option A. Purchasing a firearm safety training manual and completing a self-study program, then submitting a self-attested document confirming completion of the manual's contents. Option B. Submitting a certificate from a firearms safety course completed in a different state, assuming the course content was comprehensive, without first confirming its acceptance by Rhode Island authorities. Option C. Obtaining a certificate of completion from a firearms safety course conducted by an instructor certified by the Rhode Island State Police or a similarly recognized state authority, and submitting this certificate with the application. Option D. Presenting a notarized affidavit detailing extensive personal experience handling firearms, claiming this experience is equivalent to formal safety training. The correct answer is C. Obtaining a certificate of completion from a firearms safety course conducted by an instructor certified by the Rhode Island State Police or a similarly recognized state authority, and submitting this certificate with the application. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for obtaining a Rhode Island license to carry a pistol or revolver, particularly concerning the documentation of training and the potential for misrepresentation. The applicant must understand that honesty and adherence to the stated requirements are paramount, and any attempt to circumvent or falsify information can have serious consequences. The challenge lies in ensuring the applicant understands that the issuing authority relies on truthful and accurate submissions. Correct approach analysis. The best professional practice involves the applicant submitting all required documentation accurately and truthfully, including proof of firearms safety training from a certified instructor as mandated by Rhode Island law. This approach is correct because Rhode Island General Laws Title 11, Chapter 47, Section 11-47-11 explicitly requires applicants for a pistol or revolver license to demonstrate proficiency in the safe handling and use of firearms, typically through a certified course. Submitting a certificate that accurately reflects completed training from a Rhode Island-approved instructor fulfills this legal mandate. This ensures transparency and compliance with the state's licensing process, preventing any potential for disqualification or future legal issues. Incorrect approaches analysis. Submitting a certificate of training that was not actually completed or was obtained from an uncertified individual is a direct violation of Rhode Island's licensing requirements and potentially constitutes fraud. This approach fails because it misrepresents the applicant's qualifications and undermines the integrity of the licensing process, which is designed to ensure public safety. Presenting a certificate from a course completed in another state without verifying its Rhode Island-specific acceptance or equivalency is also problematic. While some out-of-state training might be recognized, Rhode Island law often requires specific adherence to its own safety course standards or a demonstration of equivalent proficiency as determined by the issuing authority. Failing to confirm this equivalency risks rejection of the application. Claiming to have extensive prior experience as a substitute for formal training, without providing any verifiable documentation of that experience or a recognized alternative certification process, is also insufficient. Rhode Island law generally mandates a specific type of safety training. An informal experience, while valuable, does not typically meet the explicit statutory requirements for a license. Professional reasoning. Professionals involved in the licensing process, including applicants and issuing authorities, must prioritize accuracy, honesty, and strict adherence to the specific legal requirements of Rhode Island. A robust decision-making framework involves 1. Thoroughly understanding the explicit requirements of Rhode Island General Laws Title 11, Chapter 47, particularly Section 11-47-11 regarding firearms training. 2. Verifying the credentials of any training provider to ensure they are certified and recognized within Rhode Island. 3. Submitting only truthful and accurate documentation. 4. Seeking clarification from the issuing authority if there is any ambiguity regarding training requirements or the acceptance of alternative certifications. Question 14. Regulatory review indicates that an applicant for a Rhode Island license or permit to carry a pistol or revolver has a past arrest for a minor offense that occurred over 10 years ago. The applicant was not convicted, and the record of the arrest has since been sealed. When completing the permit application, which requires disclosure of all arrests, the applicant is considering whether to include this specific arrest. What is the most appropriate course of action for the applicant to ensure compliance with Rhode Island law and the permit application process? Option A. Fully disclose the arrest on the application, providing all requested details, even though the charges were not filed and the record is sealed. Option B. Only disclose arrests that resulted in a conviction, as the current arrest did not lead to a conviction. Option C. Omit the arrest from the application, assuming that a sealed record and a lack of conviction make it irrelevant. Option D. Disclose the arrest only if the applicant believes it might be discovered through a background check. The correct answer is A. Fully disclose the arrest on the application, providing all requested details, even though the charges were not filed and the record is sealed. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to navigate the nuanced requirements for obtaining a Rhode Island pistol permit, specifically concerning the declaration of past legal issues. The challenge lies in accurately and truthfully disclosing information that could impact eligibility, balancing the legal obligation to be forthright with the desire to obtain the permit. Misrepresenting or omitting information, even if perceived as minor, can have serious consequences. Correct approach analysis. The best professional approach involves a complete and truthful disclosure of all requested information, including any past arrests, regardless of whether charges were filed or the outcome of the proceedings. This aligns with Rhode Island General Laws, Chapter 11-47, which mandates that applicants for a pistol permit must provide accurate information on their application. Specifically, Rhode Island law requires disclosure of any arrests, even if the record has been sealed or expunged, as the licensing authority has a right to know about all interactions with law enforcement. Failing to disclose a past arrest, even for a minor offense that did not result in a conviction, can be grounds for denial or revocation of a permit, as it demonstrates a lack of candor and a potential disregard for the application process. Incorrect approaches analysis. One incorrect approach is to only disclose arrests where charges were formally filed and resulted in a conviction. This is a regulatory failure because Rhode Island law requires disclosure of all arrests, not just those leading to convictions. The licensing authority needs a comprehensive understanding of an applicant's history. Another incorrect approach is to assume that an arrest that occurred many years ago, or one that was minor, does not need to be disclosed. This is an ethical and regulatory failure as it involves making a subjective judgment about what information is relevant, which is the purview of the licensing authority, not the applicant. All arrests must be disclosed as per the application's requirements. A further incorrect approach is to omit the arrest entirely, believing it will not be discovered or is irrelevant. This is a significant regulatory and ethical failure. It constitutes a misrepresentation on the application, which can lead to immediate denial, revocation of any permit issued, and potential criminal penalties for providing false information. Professional reasoning. Professionals facing similar situations should adopt a when in doubt, disclose mentality. The decision-making framework should prioritize absolute transparency and adherence to the letter of the law. Applicants should carefully read and understand every question on the application form. If there is any ambiguity about what information is required, they should seek clarification from the issuing authority rather than making assumptions. The focus should always be on providing complete and accurate information to demonstrate good character and respect for the legal process. Question 15. Performance analysis shows that an applicant for a Rhode Island license or permit to carry a pistol or revolver is unsure if their out-of-state identification card, issued by a neighboring state's Department of Motor Vehicles, qualifies as proper identification as required by Rhode Island General Laws, Title 11, Chapter 20. What is the most prudent course of action for this applicant? Option A. Rely on a passport as proper identification, without verifying if it meets the specific requirements for a Rhode Island pistol permit. Option B. Proactively contact the Rhode Island State Police or the designated issuing authority to confirm if the out-of-state identification card is acceptable as proper identification for the permit application. Option C. Include a utility bill along with the out-of-state identification card, believing that supplementary documentation will satisfy any potential deficiencies. Option D. Submit the application with the out-of-state identification card, assuming that any government-issued identification will be accepted. The correct answer is B. Proactively contact the Rhode Island State Police or the designated issuing authority to confirm if the out-of-state identification card is acceptable as proper identification for the permit application. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the nuanced requirements for obtaining a Rhode Island pistol permit, specifically concerning the definition of proper identification and the potential for misinterpretation or omission of crucial documentation. The applicant's understanding of what constitutes acceptable proof of identity, beyond a standard driver's license, is critical to a successful application and avoiding delays or outright denial. The challenge lies in ensuring all required elements are presented accurately and in accordance with Rhode Island general laws. Correct approach analysis. The best professional approach involves the applicant proactively seeking clarification from the Rhode Island State Police or the issuing authority regarding acceptable forms of proper identification if their primary form, e.g., driver's license, is not sufficient or if they have alternative forms they wish to present. This demonstrates diligence and a commitment to fulfilling all application requirements as stipulated by Rhode Island general laws, specifically Title 11, Chapter 20, concerning firearms. This proactive step ensures that the applicant understands the precise definition of proper identification as interpreted by the authorities, thereby minimizing the risk of application rejection due to insufficient or improper documentation. Incorrect approach is analysis. Submitting an application with only a standard driver's license without verifying if it meets the specific proper identification criteria for a Rhode Island pistol permit is an incorrect approach. This could lead to rejection if the issuing authority has stricter requirements than what the applicant assumes. Relying solely on a Social Security card as proper identification without prior confirmation from the Rhode Island State Police is also incorrect, as it may not be considered sufficient proof of identity for firearm permit applications under Rhode Island law. Assuming that any government-issued identification is automatically acceptable without confirming it meets the specific definition of proper identification for this particular permit application is a flawed approach, as the law may outline specific acceptable documents or combinations thereof. Professional reasoning. Professionals in this situation should adopt a framework of diligent inquiry and adherence to specific legal requirements. When faced with ambiguity regarding application documentation, the primary step is to consult the official guidelines provided by the issuing authority, in this case, the Rhode Island State Police, or to directly contact them for clarification. This ensures that all submitted information is compliant with Rhode Island general laws, Title 11, Chapter 20, and avoids potential pitfalls that could jeopardize the permit application. The decision-making process should prioritize accuracy, completeness, and explicit confirmation of requirements over assumptions. Question 16. The assessment process reveals that an applicant for a Rhode Island pistol or revolver permit has a past arrest where the charges were subsequently dismissed. When completing the application form, which requires disclosure of any arrests, how should the applicant proceed to ensure compliance with Rhode Island general laws? Option A. Fully disclose the arrest and the fact that the charges were dismissed. Option B. Only disclose arrests that resulted in a conviction. Option C. Omit the arrest from the application, assuming an expunged record requires no disclosure. Option D. Disclose the arrest but not the outcome, hoping the authorities will not investigate further. The correct answer is A. Fully disclose the arrest and the fact that the charges were dismissed. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to navigate the application process for a Rhode Island pistol/revolver permit while dealing with a potentially disqualifying past event. The challenge lies in accurately and truthfully representing one's history to the Rhode Island State Police, as omissions or misrepresentations can lead to denial and potential legal repercussions. Careful judgment is required to ensure full compliance with Rhode Island general laws, specifically those pertaining to firearm permits. Correct approach analysis. The best professional practice involves a complete and truthful disclosure of all relevant information on the application, including any past arrests, even if charges were dismissed or expunged. This approach aligns with the spirit and letter of Rhode Island general laws, which mandate that applicants provide accurate information. Specifically, Rhode Island General Laws Section 11-47-15 requires applicants to provide truthful answers to all questions on the application. While expungement may remove a record from public view, it does not necessarily absolve an applicant from disclosing the underlying event when specifically asked about arrests or convictions on a permit application. Full disclosure demonstrates honesty and respect for the regulatory process, increasing the likelihood of a fair review by the Rhode Island State Police. Incorrect approach is analysis. Failing to disclose a past arrest, even if the charges were dismissed, is a direct violation of the requirement for truthful and complete answers on the permit application. This omission can be interpreted as an attempt to conceal information, which is grounds for denial under Rhode Island law. The Rhode Island State Police are entitled to a full picture of an applicant's history to assess their suitability for a permit. Providing only partial information, such as mentioning the arrest but not the outcome, dismissal, is also problematic. While it is an attempted disclosure, it is incomplete and can lead to misinterpretation or further investigation that could have been avoided with full transparency. This approach still falls short of the comprehensive disclosure expected. Assuming that an expunged record means no disclosure is necessary is a critical misunderstanding of the application process. Expungement pertains to the public accessibility of records, not necessarily to the applicant's obligation to disclose the event when directly questioned on a permit application. The Rhode Island State Police may have independent means of accessing or verifying information, and a deliberate omission can be viewed as a lack of candor. Professional reasoning. Professionals in this situation should adopt a decision-making framework that prioritizes transparency and strict adherence to the law. This involves 1. Thoroughly reading and understanding all questions on the Rhode Island pistol/revolver permit application. 2. Consulting Rhode Island general laws pertaining to firearm permits if any question is unclear, particularly regarding disclosure requirements for past arrests or legal proceedings. 3. Being prepared to disclose all relevant information, even if it seems minor or has a favorable outcome, as the authorities are the ultimate arbiters of suitability. 4. Recognizing that honesty and completeness are paramount to a successful and lawful application process. Question 17. Stakeholder feedback indicates that individuals applying for a license or permit to carry a pistol or revolver in Rhode Island may encounter situations where their personal moral or ethical beliefs conflict with certain aspects of the application process or the legal requirements for carrying a firearm. Considering the Rhode Island general laws governing firearms permits, which of the following represents the most responsible and legally compliant course of action for an applicant in such a situation? Option A. Proceed with carrying a firearm without a permit, believing that personal moral conviction supersedes the legal requirement for a permit in Rhode Island. Option B. Submit the application with a personal statement detailing moral objections to specific firearm regulations, hoping for an exemption. Option C. Seek advice from informal sources or community groups on how to bypass or interpret the Rhode Island firearm permit laws to align with personal beliefs. Option D. Thoroughly review the Rhode Island general laws pertaining to pistol and revolver permits. Honestly assess whether personal beliefs prevent meeting all legal requirements, and if so, withdraw the application rather than misrepresent any information. The correct answer is D. Thoroughly review the Rhode Island general laws pertaining to pistol and revolver permits. Honestly assess whether personal beliefs prevent meeting all legal requirements, and if so, withdraw the application rather than misrepresent any information. Explanation. Scenario analysis. This scenario presents a professional challenge involving a potential conflict between a licensee's personal beliefs and their obligation to uphold the law. The licensee must navigate the legal requirements for obtaining a permit to carry a pistol or revolver in Rhode Island, while also considering their personal moral stance. The core of the challenge lies in ensuring that personal beliefs do not impede the lawful process or lead to misrepresentation, which could have serious legal and ethical consequences. Correct approach analysis. The best professional practice involves a direct and honest engagement with the legal requirements of the Rhode Island application process. This approach prioritizes adherence to the law by seeking to understand and fulfill all mandated criteria for obtaining a permit to carry a pistol or revolver. It involves proactively addressing any potential conflicts between personal beliefs and legal obligations by consulting the relevant Rhode Island statutes and regulations governing firearms permits. If personal beliefs genuinely prevent the applicant from meeting a legal requirement, the ethical and lawful course of action is to withdraw the application rather than misrepresent their situation. This approach ensures transparency and compliance with Rhode Island general laws, specifically those pertaining to the issuance of pistol and revolver permits. Incorrect approaches analysis. One incorrect approach involves misrepresenting one's intentions or circumstances on the application to circumvent personal moral objections. This is a direct violation of the legal requirement for truthful disclosure on official applications and could lead to the denial of the permit or revocation if already issued, as well as potential criminal charges for making false statements. Another incorrect approach is to ignore the legal requirements altogether and proceed with carrying a firearm without a valid permit, based solely on personal belief that such a permit should not be required. This directly contravenes Rhode Island law and exposes the individual to significant legal penalties, including fines and imprisonment. A further incorrect approach is to seek loopholes or informal understandings outside the established legal framework. This demonstrates a lack of respect for the regulatory process and can lead to unintended legal consequences, as the law is clear on the specific procedures for obtaining a permit. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves 1. Thoroughly understanding the specific legal requirements of Rhode Island law for obtaining a pistol or revolver permit. 2. Honestly assessing one's ability to meet all these requirements, including any personal beliefs that might create a conflict. 3. If a conflict exists, seeking clarification from the issuing authority or legal counsel regarding the specific legal obligations. 4. If unable to meet legal requirements due to personal beliefs, withdrawing the application rather than engaging in any form of misrepresentation or unlawful conduct. Question 18. Market research demonstrates that applicants for a Rhode Island license or permit to carry a pistol or revolver often face situations where past interactions with law enforcement, such as arrests that did not lead to convictions, may arise during the application process. An applicant, Mr. Smith, is completing his application and recalls being arrested for disorderly conduct 5 years ago, though the charges were later dismissed. He was also convicted of simple assault 3 years ago. When asked on the application to disclose all arrests, charges, and convictions, which of the following approaches best reflects the required standard of disclosure under Rhode Island law? Option A. Disclose both the arrest for disorderly conduct and its dismissal and the conviction for simple assault, as the application requires disclosure of all arrests, charges, and convictions. Option B. Explain that minor incidents that did not result in a conviction are not relevant and therefore should not be disclosed. Option C. Disclose only the conviction for simple assault, as the arrest for disorderly conduct did not result in a conviction and is therefore not relevant. Option D. State that only convictions need to be reported and therefore omit the arrest for disorderly conduct. correct answer is A. Disclose both the arrest for disorderly conduct and its dismissal and the conviction for simple assault, as the application requires disclosure of all arrests, charges, and convictions. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to accurately and truthfully disclose all relevant information on a critical application, even if they believe certain details might negatively impact their application. Failure to do so can have severe legal and ethical consequences, including denial of the permit, revocation of any previously issued permit, and potential criminal charges. The applicant's perception of the relevance of past events is subjective, making it crucial to err on the side of full disclosure. Correct approach analysis. The best professional practice involves providing a complete and truthful account of all requested information, including any past arrests, regardless of whether the applicant believes they were minor or resulted in a dismissal. This approach aligns with the fundamental principle of honesty and transparency required by the Rhode Island application process for a pistol or revolver permit. Rhode Island General Laws Section 11-47-11 mandates that any person seeking a permit must provide truthful information on the application. The licensing authority has the responsibility to assess the applicant's suitability based on all disclosed information, and withholding relevant details, even if seemingly minor, undermines this process and violates the spirit and letter of the law. Full disclosure allows the authorities to conduct a thorough background check and make an informed decision. Incorrect approaches analysis. Providing only the conviction for the assault charge while omitting the arrest for disorderly conduct is a failure to provide complete information. Even if the disorderly conduct charge was dismissed or resulted in no conviction, the arrest itself is a matter of public record and is relevant to a background investigation. Omitting it suggests an attempt to conceal information, which is a direct violation of the application's requirement for truthful and complete disclosure. Stating that only convictions need to be reported, and therefore omitting the arrest for disorderly conduct, is a misinterpretation of the application's requirements and Rhode Island law. The application typically asks for arrests, charges, and convictions. Rhode Island General Laws Section 11-47-11 requires disclosure of information relevant to the applicant's fitness to possess a firearm, and arrests are considered relevant by licensing authorities. Claiming that minor incidents that did not result in a conviction are not relevant and therefore should not be disclosed demonstrates a subjective judgment that is not permitted. The licensing authority, not the applicant, determines what is relevant. Failing to disclose the arrest for disorderly conduct, even if it was dismissed, prevents the authorities from making a fully informed decision and constitutes a material omission on the application. Professional reasoning. Professionals in any regulated field must approach applications with a commitment to absolute truthfulness and completeness. When in doubt about the relevance of information, the decision-making framework should prioritize full disclosure. This involves carefully reading all application instructions and questions, understanding that arrests and charges are distinct from convictions and often require separate disclosure. If an applicant is unsure about what to disclose, they should seek clarification from the issuing authority or consult legal counsel rather than making a subjective determination about relevance. The guiding principle is transparency, as any attempt to withhold information, however minor the applicant perceives it to be, can lead to severe repercussions. Question 19. Operational review demonstrates that an applicant for a Rhode Island license or permit to carry a pistol or revolver is completing the application form. The applicant was arrested in Massachusetts 5 years ago for a misdemeanor offense, but the charges were subsequently dismissed by the court before a conviction. The application form contains a question asking, "Have you ever been arrested for any crime, regardless of whether the charges were dismissed or resulted in a conviction? What is the most appropriate course of action for the applicant to ensure compliance with Rhode Island's firearms licensing requirements?" Option A. Fully disclose the arrest and the fact that the charges were dismissed, providing any requested details about the incident. Option B. Only disclose arrests that resulted in a conviction, as dismissed charges are not relevant to the licensing decision. Option C. Wait for the Rhode Island State Police background check to potentially uncover the arrest and then provide information if asked. Option D. Answer no to the question, believing that since no conviction occurred, the arrest is not legally significant for disclosure purposes. The correct answer is A. Fully disclose the arrest and the fact that the charges were dismissed, providing any requested details about the incident. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to navigate the nuances of Rhode Island's firearms licensing regulations, specifically concerning the disclosure of past legal encounters. The challenge lies in accurately interpreting the scope of what must be disclosed and understanding the potential consequences of incomplete or misleading information, which can directly impact the licensing decision and future firearm ownership rights. Careful judgment is required to ensure full compliance with Rhode Island general laws. Correct approach analysis. The best professional practice involves a proactive and transparent approach to disclosure. This means fully and truthfully answering all questions on the application, including those pertaining to arrests, even if charges were dismissed or never formally filed. Rhode Island law requires disclosure of all arrests, regardless of the outcome, to allow the licensing authority to conduct a thorough background investigation. Failing to disclose an arrest, even if it did not result in a conviction, can be considered a material misrepresentation on the application, leading to denial or revocation of a license. This approach aligns with the spirit and letter of Rhode Island General Laws Chapter 11-47, which governs firearms. Incorrect approaches analysis. Providing only information about convictions or charges that resulted in a conviction is a significant regulatory failure. Rhode Island law mandates disclosure of arrests, not just convictions. This approach misinterprets the scope of the disclosure requirement and can be viewed as an attempt to conceal relevant information, which is a direct violation of the application's truthfulness requirements. Answering no to questions about arrests if the applicant believes the arrest was unlawful or unjustified is also a regulatory failure. Licensing authority, not the applicant, determines the legality and relevance of an arrest during the background check process. The application requires disclosure of the event itself, not the applicant's personal legal interpretation of its validity. This approach bypasses the established review process and constitutes a misrepresentation. Waiting for the licensing authority to discover the arrest during the background check before disclosing it is a failure of proactive disclosure. The application process is designed for the applicant to provide all necessary information upfront. Relying on the background check to reveal information that should have been voluntarily disclosed is a breach of trust and can be interpreted as an attempt to mislead. Professional reasoning. Professionals should approach licensing applications with a commitment to absolute honesty and thoroughness. When in doubt about what needs to be disclosed, it is always best to err on the side of overdisclosure and provide all potentially relevant information. Consulting the specific language of the Rhode Island general laws and the application instructions is crucial. If ambiguity persists, seeking clarification from the issuing authority or legal counsel is advisable before submitting the application. The decision-making framework should prioritize transparency, compliance with statutory requirements, and understanding the licensing authority's need for complete information to assess an applicant's suitability. Question 20. Quality control measures reveal a discrepancy in the fee charged to an applicant for a Rhode Island license or permit to carry a pistol or revolver. The applicant, who has a valid Rhode Island driver's license and works full-time in Providence, has an out-of-state mailing address. The standard statutory fee for a Rhode Island resident is $100. Based on Rhode Island general laws, what is the correct fee to charge this applicant? Option A, $150. Option B, $75. Option C, $100. Option D, $000. The correct answer is C, $100. Explanation. Scenario analysis. This scenario presents a professional challenge involving the accurate calculation of fees for a pistol permit application in Rhode Island. Miscalculating fees can lead to either undercharging, causing financial loss to the state and potentially violating fee collection regulations, or overcharging, which can be seen as an unfair burden on applicants and may also violate statutory fee limits. The applicant's situation, involving a potential out-of-state address, adds a layer of complexity that requires careful adherence to Rhode Island general laws. The core challenge lies in applying the correct fee structure as defined by Rhode Island statutes, ensuring both compliance and fairness. Correct approach analysis. The best professional practice involves meticulously reviewing the Rhode Island general laws pertaining to pistol permit fees and cross-referencing them with the applicant's specific circumstances. This means identifying the exact statutory fee for a Rhode Island resident applying for a permit to carry a pistol or revolver. If the applicant has a connection to Rhode Island, e.g., employment, property ownership, but resides elsewhere, the specific provisions within Rhode Island law that address such situations must be consulted to determine the applicable fee. The correct approach is to apply the statutory fee of $100,000, as stipulated by Rhode Island General Laws Section 11-47-12A, which clearly defines the fee for a Rhode Island residence permit. This approach ensures strict adherence to the law and avoids any financial impropriety. Incorrect approaches analysis. One incorrect approach involves applying a fee based on a general understanding of permit costs without consulting the specific Rhode Island statutes. This could lead to charging an arbitrary amount, such as $75,000, which is not supported by Rhode Island General Laws Section 11-47-12A, and would therefore be a regulatory failure. Another incorrect approach is to assume that an out-of-state address automatically disqualifies an applicant or necessitates a different, unspecified fee. Rhode Island law does not mandate a higher or different fee for applicants with out-of-state addresses if they otherwise meet the residency or qualifying criteria for a permit. Charging $150,000 without specific statutory authority for this increased fee would be a violation of the established fee structure. A further incorrect approach is to waive the fee entirely, perhaps due to the applicant's perceived inconvenience or a misunderstanding of the fee's purpose. Rhode Island General Laws Section 11-47-12A mandates the collection of the $100,000 fee for all eligible applicants, and waiving it without explicit statutory authorization would be a clear breach of financial regulations. Professional reasoning. Professionals in this role must adopt a decision-making framework that prioritizes statutory compliance and accurate financial management. This involves 1. Identifying the relevant jurisdiction and its specific laws, Rhode Island General Laws. 2. Thoroughly researching the applicable statutes for fees and eligibility requirements. 3. Carefully analyzing the applicant's specific circumstances against the statutory criteria. 4. Applying the precise fee dictated by law, ensuring no deviation without explicit legal authorization. 5. Documenting the decision-making process and the basis for the fee calculation. This systematic approach ensures fairness, legality, and professional integrity.